In the previous lectures, we've covered data privacy, security, and legal considerations. Now we turn to the regulatory landscape, the rules governments are putting in place to govern AI developments and use. This is a fast-moving area. Governments around the world are grappling with how to regulate AI, and new rules are emerging regularly. I can't give you a comprehensive global survey. That would be outdated before you finished watching. What I can do is help you understand the most significant regulatory developments to date, the EU AI Act, and give you a framework for thinking about the industry-specific requirements. Again, as with our legal discussion, this is not legal advice. Consult qualified legal counsel for specific compliance questions. My goal is to help you understand the landscape well enough to ask the right questions and have informed conversations. Let's start with the EU AI Act, which entered into force in August 2024. This is the world's first comprehensive legal framework specifically designed to regulate artificial intelligence. Even if you're not based in Europe, this matters to you, and I'll explain why. The EU AI Act takes a risk-based approach. It categorizes AI systems based on the level of risk they pose and applies different requirements accordingly. This is a sensible framework that many other jurisdictions are watching closely. There are 4 main risk categories. An acceptable risk. Some AI applications are considered so dangerous that they're prohibited outright. This includes things like social scoring systems by governments, real-time biometric identification in public spaces for law enforcement, with limited exceptions, and AI systems that manipulate human behavior in harmful ways. These prohibitions took effect in February 2025. High risk. This is the category that will affect most organizations. High-risk AI systems are those used in areas like employment and recruitment, education, credit, and insurance decisions, critical infrastructure, law enforcement, and migration and border control. These aren't prohibited, but they're subject to strict requirements. For high-risk systems, organizations must implement risk management processes, ensure data quality and governance, maintain technical documentation, enable human oversight, and meet accuracy, robustness, and cybersecurity standards. There are also transparency requirements and obligations to register systems in the EU database. Limited risk. Systems with limited risk, like chatbots or AI-generated content, have transparency obligations. Users must be informed when they're interacting with an AI system or when content has been artificially generated. This is about disclosure, not prohibition. Minimal risk. Most AI applications fall into this category. Spam filters, AI-enabled video games, inventory management systems. These are largely unregulated under the Act, though general legal requirements still apply. The Act is being phased in over time. The prohibitions on unacceptable risk systems took effect in February 2025. Requirements for general-purpose AI models apply from August 2025. Most other provisions, including high-risk system requirements, apply from August 2026. Some specific rules for high-risk systems embedded in regulated products have a longer timeline. This phased approach gives organizations time to prepare, but that time is limited. If you are deploying high-risk AI systems, compliance planning should already be underway. Now you might be thinking, I'm not in Europe. Why does this matter to me? 3 reasons. First, extraterritorial reach. The EU AI Act applies to organizations outside the EU if their AI systems are used in the EU, or if outputs from their AI systems are used in the EU. If you serve European customers or have European operations, the Act likely applies to at least some of your AI activities. Second, the Brussels effect. The EU has a track record of setting regulatory standards that become global norms. GDPR, the EU's data protection regulation, has influenced privacy laws worldwide. Many expected the AI Act to have similar effect, not because other countries will copy it exactly, but because it establishes concepts and frameworks that others will adapt. Third, supply chain implications. Even if you don't directly serve European markets, your customers or partners might. AI systems often flow through supply chains, A tool you develop might be used by a company that serves European customers. Understanding EU requirements helps you anticipate what your business partners may require of you. The US has taken a more sector-specific approach rather than comprehensive legislation. Executive orders have established AI safety guidelines for federal agencies. Various states are introducing their own AI laws, particularly around employment and consumer protection. Industry-specific regulators, financial services, healthcare, transportation, are incorporating AI into their existing frameworks. For the United Kingdom, post-Brexit, the UK has signaled a pro-innovation approach to AI regulation, relying more on existing regulators adapting their frameworks than on comprehensive new legislation. However, specific rules are emerging in areas like financial services and healthcare. China has implemented regulations covering algorithmic recommendations, deep synthesis, deepfakes, and generative AI. These focus heavily on content control and require registration and approval for certain AI services. Other jurisdictions, Canada, Brazil, Japan, Singapore, and many others, are developing AI governance frameworks. The approaches vary, but common themes include transparency, accountability, and risk management. Beyond horizontal AI regulation, many industries have specific requirements that affect AI use. Let me highlight a few. Financial services. Financial regulators globally are focused on model risk management, fairness in lending and insurance decisions, and explainability. If you're using AI for credit decisions, trading, fraud detection, or customer advice, you'll likely face specific supervisory expectations. In the US, the Federal Reserve and OCC have model risk management guidance. In the EU, financial services AI will be subject to both the AI Act and sector-specific regulation. Healthcare. Medical AI is typically regulated as a medical device, which brings substantial requirements around safety, efficacy, and clinical validation. The FDA in the US, the EMA in Europe, and equivalent bodies elsewhere have frameworks for AI-based medical devices. Healthcare AI also implicates patient data privacy under regulations like HIPAA in the US. Employment. AI in hiring and employment decisions is receiving increasing regulatory attention. Several US states and cities have laws requiring bias audits for automated employment decision tools. The EU AI Act classifies employment-related AI as high risk. Discrimination laws in most jurisdictions apply to AI-based decisions, just as they do to human decisions. Critical infrastructure. AI used in energy, transportation, telecommunications, and other critical infrastructure faces heightened scrutiny around security, reliability, and resilience. How should you navigate this complex and evolving landscape? Let me offer some practical guidance. First, know your exposure. Map your AI systems and understand where they're deployed, who uses them, and what decisions they influence. This is the foundation for understanding which regulations apply. Second, classify your risk. Using the EU AI Act categories as a framework, even if you're not directly subject to it, assesses which of your AI applications might be high risk. These deserve the most attention. Third, build compliance into design. It's much easier to build documentation, human oversight, and transparency into AI systems from the start than to retrofit them later. If you're developing or procuring AI systems now, build with future compliance requirements in mind. Fourth, engage with regulators and industry bodies. Regulators are still figuring this out, and many welcome input from the industry. Industry associations often provide guidance and best practices. Engaging proactively is better than waiting for enforcement. Fifth, monitor developments. This landscape is changing rapidly. Build in mechanisms to track regulatory developments, whether through legal counsel, industry associations, or dedicated monitoring. What's compliant today may not be tomorrow, and vice versa. Regulation can feel like a burden, but I'd encourage you to see it differently. Clear rules create a level playing field. They build public trust in AI, which enables broader adoption. And they push organizations toward practices, transparency, accountability, human oversight that are good for business, not just for compliance. The organizations that will thrive are those that view responsible AI practices not as a regulatory overhead, but as a competitive advantage and a foundation for sustainable AI adoption. In the next lecture, we'll look at ethical frameworks, the principles that guide responsible AI use beyond what the law requires.